Before lunch, I just finished on the grounds of appeal, and obviously our submission on those is that we would invite you to refuse permission to appeal on the grounds that the appeal is not realistically arguable on the merits, or in any event, if you grant permission to dismiss the appeal on each of the grounds. There was one point I intended to pick up when I was dealing with the facts, and I didn't. I'm not sure where it goes, but my learned friend took you to some paragraphs of the judgment suggesting, I think, that there was some inconsistency because the judge had found that one of the documents came from Chancellor's colleague, and therefore it couldn't have been improperly provided because Mr. Chancellor had been acquitted of...
Yeah, I couldn't quite follow what it was when we actually looked at the material, because it didn't seem to be anything suggesting one way or the other whether it should have been obtained properly or improperly.
My Lord, I'd say three things. Firstly, that it's not clear where it really went. Secondly, even if it was clear where it went, it goes nowhere because it's a substance point, and you can't make a disguised challenge to the substance by dressing it up as a reasons point and pointing to an inconsistency. That's just a challenge to the merits. But the premise of it was in any event wrong. Can I just show you one paragraph of the judgment, which is Core Bundle A, tab 4, page 176. And it's paragraph 428. Because although my learned friend is right to say that Mr. Chancellor was cleared, if you like, of having deliberately or corruptly agreed to throw the arbitration, the judge did not clear Mr. Chancellor or his colleagues of being involved in the corrupt provision of documents. What he says is that area is far from free of suspicion by reference to the evidence I do have, but there are many unanswered questions and alternative possibilities. I've therefore declined to reach that inference because it's unsuitably broad. So in terms of the provision of documents, the judge simply left it as it's an open question who was corrupted into providing them. I don't need to decide it. But what you certainly can't do is what my learned friend tried to do, which is reason, well, Mr. Chancellor was cleared, therefore if a document was provided by Mr. Chancellor, it must have been legitimately provided, because that's inconsistent with the judge's own finding, that he's simply not going to decide that one way or the other. It's open to questions, but he's not going to reach a conclusion broadly that all of these people were.
Well, what the judge says at 210 is that I've reviewed these internal documents, at least some of them plain subject to legal professional privilege, confidential to Nigeria, and PNID was not entitled to see them. Which is, and then he goes through the specific documents.
Yes.
In a way in which you've pointed out. But I mean, what that isn't saying is that well, it's a point that we touched on this morning, isn't it? It's a point that Mr. Andrew accepted in cross-examination. The judge is certainly not saying that these documents were being disclosed by Nigeria on an authorised basis.
No.
Who it was? I mean, there's some evidence of, I think, 3 individuals who look as if they're probably aliases.
Yes.
So obviously there were people within the Nigerian bureaucracy who were leaking these documents in an illicit way. But in a sense, it doesn't matter, does it?
That's the point.
Because what matters is that PNID had the documents when they knew they shouldn't have had them, and because they were confidential and most of them were privileged.
Precisely. And all I wanted to do is lay to rest this idea that there was some process by which you could reverse out of the judgment some inconsistency. That takes me to the discretionary grounds, by which I mean, were your lordships to conclude that there was otherwise an arguable appeal, why I say that you should nevertheless refuse permission. And really what I'm going to do is just echo the findings in grey. So if your lordships wouldn't mind turning that up again, it's Authorities Bundle B at tab 22. at page 478, where Lady Justice Gloucester explained why she, in that case, would have refused permission. Authorities B, tab 22, I hope. Tab 22, and it's page 478.
Yeah.
So obviously the points made in paragraph 46 are wholly inappropriate to afford Mr. Gray, who's not a party to the proceedings, a remedy by way of an appeal after a full evidentiary hearing, finding that Mr. Gray had been honest, no interest of any actual party in being litigated, and the trial of the main action being concluded with the action being dismissed and the litigation being over because permission to appeal hadn't been obtained by any of the parties. All of that applies equally here. Full trial, determination, no party has any interest, action is over, permission to appeal has been refused by Mr. Justice Robin Knowles, and that is final as regards the parties. And then what the Lead Justice Gloucester did in paragraph 47 was to recognise that there was a need to balance Article 6 and Article 8 rights, in that if there had been an interference in Mr. Gray's Article 8 rights, that interference could be justified in accordance with the law for the protection of the rights and freedoms of others, and the rights and freedoms of others included the party's Article 6 rights, which included the right to finality in the litigation. You see that about 6 lines up. They are entitled to finality in their litigation within a reasonable time, not to be subjected to further appeals at the suit of a non-party, with the consequent risk as to costs, merely on the basis of Mr. Gray's contention that the process was unfair to him as a witness. And my lords, we say plainly the Republic of Nigeria has a Article 6 right to finality in this litigation, and we say that finality is engaged in 2 respects, the first being judgment, the second being process. Plainly, the FRN has a strong, very strong interest in nothing being done which may affect the finality of the judgment which it has obtained. And although I've submitted that there is nothing that could come from this appeal which in fact would properly addressed result in the Section 68 judgment being undermined, the mere fact that there could well be challenges to the Section 68 decision by PNID seeking to reopen somehow.
Well, that's the point, isn't it? That if we were to blue pencil the judge's findings in relation to Mr. Andrew, then it is conceivable that PNID will pop up again and say, well, in light of that, you, judge, would go first of all to the judge, I think. You, judge, should revisit your decision to refuse permission to appeal.
Quite.
For the following. Now, whether that's even begins to be feasible and arguable and so on and so forth, it isn't the point. I mean, the point is if you've got finality because of once the judge has said, no, I refuse permission to appeal, there's no right to come to this court, then that should be the complete end of it. Full stop.
Quite. And the reality, my lords, is that the ingenuity of lawyers knows few bounds. And if your lordship start tinkering, if I can be forgiven for using the word, with the judgment, one expects that PNID will look for a way of exploiting that. And they'll no doubt say they've got some Article 6 rights and now the judgment's been undermined. There's got to be an avenue by which they can have that taken into consideration. It will all be rubbish, but unfortunately it will mean a raft of costs, a raft of time. And that's not what finality is about. Equally, I've made the point that there could in theory be proceedings in foreign jurisdictions. People can try and enforce awards in other jurisdictions. And there may be questions about whether the set-aside is effective if it's the Court of Appeal has said part of the reasoning was not appropriate. Now, again, we would submit that's a hopelessly bad argument, but the fact there may even be a doubt as to the efficacy of the judgment in other proceedings, it is a reason why it shouldn't simply something you shouldn't contemplate. Finality also in process. I recognise that in practical terms, this now has less impact because we've been here and argued out the appeal in full as a rolled up hearing. But Nigeria is entitled to finality in not having to continue spending money in these proceedings. And the reality is that by facing this sort of appeal, it is dragged into more hearings, more cost, more time on things that it has no interest in. And it's frankly no good for Mr. Andrew to say self-servingly, oh, well, you could just stand by and let me do my appeal and not run up any costs. Because as Lady Justice Gloucester says at the end of paragraph 47, we have to have regard to what might be the consequences for us of upsetting findings of fact. And in any event, looked at from your Lordship's perspective, hopefully there has been a benefit to us being here. And it's part of we see it as part of our role as being the only party able to put the other side of the appeal to do that.
Well, it's the same situation as in Borry, isn't it? In Borry, it was Mr. Gray had been the solicitor for the Republic, and they didn't take any part in this part, in the proceedings involving his misconduct. So, I mean, on the basis that somebody had to respond, as it were, in that case, Mr. Roy was the person.
Yes, and therefore the practical effect is to undermine finality of the process, because in practice we are dragged into something that Section 68 envisages can't happen, an appeal without the judge's interest, without the judge's permission, and an appeal in which actually has no, is not related to the actual decision made. So we say this is a case where our Article 6 rights are certainly engaged, and when one gets to the balancing exercise, if they are conflicting rights, are, as in Gray, our Article 6 rights weigh far more heavily than Mr. Andrews' Article 8 rights. Now, I recognise that in Gray, one thing that did weigh in Lady Justice Gloucester's consideration was the reality that there might have to be a remission if the appeal succeeded. I accept that's not a factor here. But equally, in this case, we have the added factor that it is an arbitration-related matter, and therefore finality always has a higher weighting.
Well, you say, I mean, I don't know. If this court were concerned about whether the judge's findings were sufficiently detailed, but felt overall that his result might be the right result, but the court would certainly have jurisdiction to remit it to him to make further findings.
Yes, my lord. I accept that, and indeed we have encouraged you, if you were to allow the appeal.
I think you may say that at the end of your skeleton.
We have invited you to.
If you do anything, please don't do anything. But if you do anything,
yes,
send it back.
Just ask for more reasons. We certainly pitch that as a simply invite the judge to give more reasons for what he's already found, yes, as opposed to a remission in the sense of rehearing, which is the Boré concern.
No,
it would be a
no remission for any other purpose, I don't think.
No. And we do say that if we say that's very, very far down the road, but if you did get there, that would be better than simply excising the findings, in part because we think the reality of this is if those findings are excised, that is going to be give a false impression that they have been set aside by the Court of Appeal, when in fact we think they are good and right findings that it's important that the court did make. And excising them would not be the just outcome on any view. So we say the Article 6 arguments fall very squarely in our favour. The second factor we rely on is the one identified in paragraph 48 of Gray, which is the presence of the SDT, which of course is also the case for Mr. Andrew, and it's as Lady Justice Gloucester found about 4 lines down, Mr. Gray will have an opportunity to vindicate his professional reputation at that hearing. So there is an alternative route to protecting, in that case, Mr. Gray's Article 8 rights, or vindicating Mr. Gray's Article 8 rights if they had been otherwise breached. She makes the point that under Rule 15.4 of the then 2007 rules, those findings of the judge would not be binding on the tribunal. So it would be open to Mr. Gray to argue that the findings were not fair and no weight should be put on them. And indeed, in the subsequent proceedings against Mr. Gray, where he was unsurprisingly struck off by the Solicitors Disciplinary Tribunal, the tribunal scrupulously reanalysed the evidence for itself. There was then a judicial review in which the judge found that the tribunal hadn't simply adopted your lordship's findings, and the same, of course.
That's the next tab at the bundle.
It is.
Mr. Justice Linden's decision in Gray and the SRA.
It is.
And the argument was run that they'd simply rubber stamp my decision, or by putting it colloquially, that was the sort of thrust of it. And the judge, in what's actually an extremely detailed judgment, rejects all that.
He does. I mean, the number of pages that have been dedicated to Mr. Gray is quite something. But yes, Mr. Justice Linden found that they couldn't.
That case didn't go to the Court of Appeal, did it?
It didn't. No. Found that they wouldn't have been entitled simply to rubber stamp, and they didn't. And the same will be true of Mr. Andrew. So, subject to anything your lordship say, it will be open to Mr. Andrew to say the reasoning in the judgment I submit is not very good, and you should form your own views on all the evidence. And importantly, Lady Justice Gloucester went further than that. She said in the final sentence that in fact the SDT was the appropriate forum for Mr. Gray to vindicate his professional reputation, which is no doubt right. The Court of Appeal is not a terribly good place with respect to be descending into these sorts of arguments. The SDT is a fact-finding tribunal which will be deciding not only the facts but matters of culpability and sanction. So it is plainly the forum which is best placed to actually investigate the matters that Mr. Gray wants to have investigated and analysed in detail. And so we do say that again, even if there were an arguable breach of Mr. Gray's Article 8 rights, this is another reason why this court does not need to provide a remedy, and another reason why our Article 6 rights should be given much greater weight, given that Mr. Andrew has an alternative and indeed appropriate forum. Now, I should say my understanding, although no doubt my own friends know better than me, is that there are not yet disciplinary proceedings on foot. Mr. Andrew remains, for better or worse, a solicitor with a full practicing certificate who is only subject to investigation. But one would have thought after this judgment and the finality to these proceedings, disciplinary proceedings are inevitable. And I do invite your lordships to proceed on the basis that this avenue will be open to Mr. Andrew.
The length of time these things take is demonstrated by the fact that the judgment of the Court of Appeal in Gray was on the 9th of February 2017, and the hearing before the SCT was on the 8th to the 16th of March 2021.
Yes, my lord. It's probably not for me to say anything more about that than it is not a speedy process. My recollection is that Mr. Gray voluntarily didn't renew his practicing certificate in the meantime, and therefore there was
he practiced in Dubai anyway.
Yes, and I believe he was practicing without needing his English practicing certificate, so there was less urgency in that sense.
No.
But it's fair to say that the regulators move at their own pace.
Mm.
But
Okay.
in any event, were the regulators to say that they were not going to refer this to the SDT, in a sense that would itself be a vindication for Mr. Andrew, in that he would no doubt say to everyone, well, the body that's been charged with investigating this in detail has looked at it and found that I've got no case to answer. Mm. So somehow or another, the investigatory process is going to provide a vindication or vindication either of Mr. Andrew's professional reputation or a vindication of its destruction by the judgment. Third, it's a relevant factor here as a matter of discretion that Mr. Andrew did not avail himself of the mechanisms available before the judge. Now, I've primarily relied upon that as a reason why there is no breach of Article 8 or Article 6 anyway, because the process as a whole was fair. But even if you found that there was an arguable case that the process was not fair, my submission is that it is a discretionary factor that this court does not need to make available exceptionally a right of appeal where the individual was given a more practical and available remedy, simply going to the judge who'd heard the trial and chose not to take it for whatever reason. And of course, I include in that saying nothing during the hearing about the case not being fairly put to him, not making representations when he received the draft judgment, and not taking up the judge's express invitation to issue a written application for permission to appeal when he was given the opportunity to do so.
Well, the judge, as he was entitled to do, clearly took the view that if he was to entertain what was on any view an unusual application, that it should be made on a formal basis with a written application notice.
Yes.
So that anybody who was interested, whether it was the parties to the proceeding, anybody else who was interested, could be made aware of the existence of the application. So it wasn't to be dealt with on a sort of informal basis.
Yes. Well,
that's all it was. And certainly you showed us the judge's email. I didn't read that as being in any sense an indication as to what his decision might be if an application were made.
No. And I won't say anything more about that. My own friend Mr. Ford is going to address you on that, so yes. I won't say anything more. On the discretionary factor, in my submission, it is a weighty matter that an individual should not come to this court with inevitably the additional burden is imposed on judicial resources on the parties if they had some other remedy available, and this court should positively discourage that by saying if you don't exhaust your remedies below, don't come here crying after the event. Fourth and final point is obviously we rely on paragraph 50 of Lady Justice Gloucester's judgment, and we invite you to say that as a general rule, save in the most extraordinary cases, this sort of satellite litigation simply isn't to be tolerated. And there may be exceptional cases where the procedure was so defective and there is no alternative remedy available either at first instance or through disciplinary bodies that the court has to make something available. But short of that truly exceptional situation, this court should firmly discourage the invocation of the re-W jurisdiction. My Lords, unless I can assist further on any of those points, I'm going to hand to Mr. Ford.
Thank you very much, Mr. Wood. Yes, Mr. Ford.
I'm going to address the lack of justification for an extension of time and the section 68(4) point.
Yeah.
Before I do so, I think it's quite helpful to give you a procedural roadmap, very briefly, of what happened following the confidential judgment being circulated. It's been summarised in our skeleton at paragraphs 33 to 35, and it's worth having that to hand, which is in the core bundle at tab 3, page 63.
35.
And as you see at paragraph 33, as has now been well trodden, the embargo judgment was in draft, was circulated on the 16th of October. Mr. Andrew received a copy of that in his capacity as a director the same day, and on the 17th of October sought and obtained permission to show it to his own counsel, expressly for the purpose of whether submissions ought to be made prior to the hand down. As is now well trodden again, no submissions were made nor reasons sought. And we've of course included in the authorities bundle at tab 45 the Re-A Children Adequacy of Reasoning case, which at paragraph 16 just highlights the expectation that parties or counsel should bring any ambiguity or perceived lack of reasons to the judge's attention.
So give me the reference to that
It's
again?
tab 45.
Tab 45.
And
It's a well-trodden path.
And the paragraph I particularly rely on is authorities bundle page 1157 and paragraph 16. But of course, that wasn't done. The consequentials hearing of one day was then fixed for the 8th of December 2023 on the 8th of November. And on the 24th of November, the judge's clerk emailed the parties, and you see that at tab 122 of the supplemental bundle.
So when was the hearing fixed?
On the 8th of November.
So on the 8th of November, it was fixed to the 8th of December.
Correct. And then on the 24th of November, if we go to the supplemental bundle at tab 122, page 1265.
The very end of that.
So, supplemental D, page 1265, the very final tab. The judge indicated it would help to have any draft grounds by 4 PM on the 1st of December, and also identified that actually this is a case in which sequential submissions be made in relation to consequential. So P&ID were to provide their skeleton for the hearing by 4 PM on the 4th of December, and Nigeria by 9 AM on the 6th of December. Now, there was no indication at any point that Mr. Andrew personally intended to seek permission to appeal, and the parties duly went to proceed with P&ID providing its skeleton by 4 PM on the 4th of December and Nigeria by 9 AM on the 6th of December. Then out of the blue, 5:20 on the 6th of December, there was a letter of Andrew's new counsel emailed to the court, and you find that in the core supplemental bundle at tab 22, page 347.
We can put this away, can we?
Yes. And so this letter was emailed accompanied by Mr. Andrews' grounds of appeal and Mr. Andrews' skeleton. And it was after both P&ID and Nigeria had served their skeletons for the hearing, so they couldn't respond to this in their skeletons. That had already happened that morning, and just one day before the consequentials hearing. So whereas the judge had envisaged any grounds of appeal being provided by the 1st of December and had provided for skeletons to be provided to be completed by 9 AM on the 6th of December, here on the afternoon of the 6th of December, for the first time unheralded, you've got Mr. Andrews' personal intervention.
Is there any explanation in the letter as to why it was that they'd failed to comply with the judge's order?
Not in the letter. I think
Direction.
we've been told subsequently, in the context of this appeal, that Mr. Andrews says he was unaware of the judge's direction. But as the director of P&ID, he must have at least been aware that P&ID had had to serve its skeleton on the 4th of December, with Nigeria skeleton served at 9 AM on the 6th of December. So his own grounds were coming after the other procedural steps in terms of skeletons.
Yeah.
On the 7th of December, which you see in the supplemental bundle at tab 117, so that's supplemental bundle D, Mr. Andrews' counsel wrote as to whether, on the 7th of December, as to whether the judge would like him to attend, stating there was unlikely to be enough time to actually accommodate a substantive hearing of the appeal. And on the next tab at 118, you see the judge's clerk's response to that, making clear it is open for counsel to attend today as it is open court, and already identifying before the hearing, as it strikes the judge at the moment, this would need a formal written issued application as a starting point. Now, no such application was issued in response, and you've seen the consequentials hearing transcript yesterday, which I wasn't going to take you back to, but the judge made clear, I'm going to require a formal application if this is even to begin, and stating I'll reserve the matter to myself. And we say the judge was entitled to determine in the exercise of his case management powers how any application should be made, particularly in the unusual circumstances of it being a non-party seeking to appeal. And indeed, as recorded in the Bora judgment at paragraph 3, in that case, Peter Gray had applied and been joined to the proceedings for the purposes of applying for permission to appeal. So that's a procedure that had been adopted in the Bora case. Now, notably,
The position was that the judge there was a hearing on the 8th of December, and the judge reserved his judgment on that, didn't he?
yes,
So he didn't actually. So the final decision on that wasn't made till the 21st of December.
he reserved his judgment on certain points. So he made some decisions
Well, that's what he says. I'm just reading his
on
judgment.
a rolling basis.
He says, at a hearing on the 8th of December, PNID sought leave to appeal under section 68(4), and Nigeria's position was leave to appeal should be refused, had the benefit of written and oral argument, and have taken time to reflect carefully, and then says I've reached this conclusion. So he hadn't indicated at the hearing on the 8th of December what his answer would be on leave on permission to appeal.
Correct, my lord.
So the suggestion that he was somehow functus at that point on the 8th of December is misconceived.
Correct, and in fact what happened was on the 21st of December, I think that was the date on which there were both a further judgment giving the court's reasons for refusing permission to appeal,
Yeah.
and also the judge himself in fact drew up the consequentials order, rather unusually. And I'll take you that consequentials order in a minute, but notably, there was no suggestion by Mr. Andrews' counsel at the consequentials hearing that the judge would become functus. And also, if he did become functus on the 8th of December, there's no explanation or justification for why Mr. Andrew then waited until the 21st of December to file the appellant's notice, having already prepared grounds and a skeleton for the hearing on the 8th of December. And it has the appearance of being...
No, just sorry to stop you, Mr. Ford. Did somebody attend, did counsel attend on behalf of Mr. Andrew? Mr. Lee attend on behalf of
on the 8th of December.
Yeah, I don't think I picked that up.
And there was a back and forth where Mr. Lee speculated about what the next step should be, and the judge effectively
Oh, I
said,
remember, yes, we did
I leave
know
that to you.
So you showed us,
Yes.
Mr. Wardell showed us a transcript. Yeah, okay.
And the waiting until the 21st of December certainly has the appearance of having deliberately waited until the judge circulated the consequentials order on the 21st of December to then seize on that to argue that the court had become functus. So waiting until that point to take the step. But I don't think we need to speculate further on that. The reality is the judge made clear at the consequentials hearing he was open to an application and was implicitly reserving jurisdiction And there are two further pieces of evidence for that. First of all, if we go to the core supplemental bundle at tab 23, and that's page 349.
Yeah.
The judge's clerk actually contacted Mr. Andrews' counsel on the 21st December, asking whether or not an application would be made. So the judge clearly considered he retained jurisdiction. And again, the judge himself drew up the order for the consequential hearing, which was circulated on the 21st December. And you find that in the core bundle. So sorry to switch bundles again, but at tab 5 of the core bundle, page 225. And at paragraph 12, the judge included generally an express liberty to apply to Mr. Justice Robin Knowles in the first instance.
Yeah.
But Mr. Andrew failed to take that up in terms of issuing a formal application. And had he done so, that was an occasion which reasons could have been given by the first instance judge had he seen it appropriate to do so. Instead, having waited for the consequentials order to be circulated, Mr. Andrew issued the appellant's notice out of time on the 21st of December 2023, seeking an extension of time. And in the core supplemental bundle, and this is the final time I hope to have to take you to that, at tab 24.
Yeah.
That's page 350. That's tab 24, page 350. You have the response of Mr. Andrews' counsel in response to that the email to Andrews' counsel asking whether an application would be made. Now saying Mr. Andrew will not now be making an application for permission to appeal to the judge. He's instead filed an appellant's notice seeking permission to appeal directly from the Court of Appeal. No disrespect is intended by seeking permission directly from the Court of Appeal. The reason for this is that the lower court is now front us.
Well, that argument we did discuss with Mr. Wardell yesterday. I have to say, speaking for myself, it seems to me to be wholly unmeritorious. Quite apart from anything else, whether the judge had granted a formal extension of time or not, the fact that the judge himself, via his clerk, was asking on the very day that he handed down his judgment on leave to appeal, on permission to appeal, and made the consequential order, whether or not an application was going to be made, and then included in the consequential order the liberty to apply, seems to me to demonstrate that if an application had been made on the 21st of December or at any time thereafter to Mr. Justice Robin Knowles for an extension of time by Mr. Andrew, the judge would have had jurisdiction to grant one and could have done so, and then the application could have been dealt with thereafter.
Yes, so our position is certainly that they should have taken the judge up on the opportunity of making a formal written application, and of course that would have then given the judge the opportunity to give written reasons if he so.
Well, or it would have given the judge the opportunity, for example, to say, well, when I said in paragraph 592 what I said, this is what I meant.
Exactly. So
it would have obviated the need to come to this court.
Yes.
Which is precisely the point that is made by Lord Justice Mumby in A. if there's something that needs clarifying, you go to the judge in the first place. What you don't do is to bypass the judge and come straight to this court and then complain about the judge's reasons when you could have asked him to clarify them.
And that, having given that whistle-stop history, that feeds directly into the first issue, which is that Mr. Andrews' appellant's notice was, as is common ground, out of time, and in the circumstances, Mr. Andrew should not be granted an extension applying the relief from sanctions criteria. We've addressed this in our skeleton at paragraph 38 to 40, but in terms of the law, it's common ground that the appellant's notice to the Court of Appeal, when it was issued on the 21st of December, was by then 5 weeks out of time, pursuant to CPR 52.12(2)b. The case of Jamous and Mercurius, which is at tab 29 of the authorities bundle, makes clear that knowing or being confused about the deadline is not a sufficient excuse for failing to comply.
Sorry.
And that's
Give me that.
it's tab 29 of the authorities bundle, which is page 826 of the authorities bundle.
Tab 29.
And we rely on paragraphs 111 to 112. And if you see it, paragraph 112 on page 826, and then paragraph 113.
No.
And so what we do say is that what Mr. Andrews should have done, as directed by the judge, was to issue and pursue a formal application before Mr. Justice Knowles, having not done so, and having not obtained an extension from the trial judge for filing an appellant's notice with the Court of Appeal at a later date per CPR 52.12(2)a, the appellant's notice was out of time pursuant to subparagraph B of that section. But moreover, insofar as Mr. Andrews' position is that the judge did not retain jurisdiction post the 8th December hearing, there's been no proper justification for excuse for Mr. Andrew holding off filing his appellant's notice until the 21st of December. In such circumstances, he should have been filing an appellant's notice immediately with the Court of Appeal.
Well, even if the argument were right that the judge was functus as of the 21st of December, it's a bit difficult to see how he was functus on the 8th of December,
Yes.
having reserved judgment.
And so,
Because apart from anything else, if he's reserved judgment on permission to appeal, and then something had come up when the judgment was handed down that one of the parties thought he'd got wrong, the idea that he couldn't correct it is just wrong.
yes, my lord, that's our position.
And if that's the position so far as the parties are concerned, it's a bit difficult to see how Mr. Andrews is in a different position.
And so, addressing the relief from sanctions criteria, we say there was a serious breach here. It's important, and it reflects the importance of appellant's notices being served in accordance with the rules and on time. There was no good reason for failure to comply. Being mistaken about the deadline isn't a good reason. And in terms of the evaluation of all the circumstances, the course that Mr. Andrew followed was disruptive. You've seen that by the fact he waited to provide his, or only provided his grounds to the judge the day before, failed to take the judge up on the opportunity given to him to issue a formal written notice, which could have then been dealt with in an ordinary way, rather than being added to a already overburdened one-day consequentials hearing. And it was also prejudicial in that, as we said, had Mr. Andrew actually proceeded with an application for the trial judge, the judge could have provided any clarity said to be needed insofar as the judge thought that was appropriate. So for all those reasons, we do say that this is a case in which the court should not grant an extension of time in circumstances where, as is common ground, the appellant's notice was out of time. Now, moving to issue 2, which is the section 68(4) of the Arbitration Act. This is addressed in our skeleton at paragraph 41. You saw, and it's worth turning up again, the relevant provision of the Arbitration Act, which is in the Authorities Bundle A, tab 1, page 7. And it's subparagraph 4, of course, 68(4) at the bottom. And it's effectively a question of statutory construction. We say the provision provides the leave of the court is required for any appeal from a decision of the court under the section. And we say, first of all, any is not restricted to an appeal by the parties. It's in broad terms. And second, that any appeal from a decision of the court under the section must include seeking to challenge the findings that are part and parcel of the court's reasoning as to whether to grant or refuse a Section 68 application. And the findings against Andrew were part of that reasoning. You've heard from my learned leader already the fact that here Andrew was an emanation of P&ID. So his actions were being relied on and his knowledge was being relied on as part of the actions and knowledge of P&ID. And although I won't turn it up, it's also worth your lordship just keeping in mind pleading at paragraph 79C of the statement of case, which is at core bundle tab 15, page 358, which again made clear that Mr. Andrew was an emanation of P&ID. Well, it's been turned up, so I might as well just show it to you. It was said by letter dated 30th December 2021, P&ID has averred that privileged documents were obtained by certain individuals, and then we pleaded, in addition, each of Mr. Cahill, Mr. Michael Quinn, Mr. Ken Smith, Mr. Neil Murray, Mr. Adam Quinn, Mr. Kachazi, Mr. Andrew, and Mr. Trevor Burke, at least, were also contemporaneously involved in the receipt of FRM privileged documents on behalf of P&ID.
Yeah.
Now, you're taken to the decision in this case in a different aspect of the case, the process and industrial developments and Nigeria decision, which is at tab 39. In contrast to today, I argued the substantive appeal, and Mr. Howard Casey argued the section 68 4-point on that one.
Let's have a look at that.
Tab 39. And as this court remembers, that case concerned whether an appeal on the court's decision on costs was precluded by section 68(4 and found not. But what the case does is it neatly summarises some of the previous key authorities.
Yeah.
And it's Authorities Bundle, page 1027, is where the case begins.
Yeah.
And you've looked at some aspects of the case already. I wanted to take you to paragraph 24 to 25, which refers to the judgment of the court in National Iranian Oil Company and Crescent. The NIOC case considered whether a decision regarding whether a party had lost under section 73 of the Act its right to object under section 67, that a tribunal had exceeded its jurisdiction was caught by section 67(4 and held it was. And at paragraph 25 of this judgment, the P&ID judgment, there is a summary, or rather they take part of the reasoning in that case. And at paragraph 25, it makes a number of points which I just draw to your lordship's attention. First of all, at paragraph 60, first, the policy underlying section 67(4 and other equivalent provisions has consistently been stating as being to avoid delay and expense. And then second, moving down to paragraph 62 of the NIOC decision as recounted in paragraph 25. Second, there are statements which suggest that a decision which is part of the process of reaching a final decision on a challenge to an award is a decision under section 67 or 68, as the case may be. And then at paragraph 63, third, there is no support in these cases for the view that only a decision finally disposing of a challenge to an award is capable of being a decision under Section 67 or Section 68, nor is any distinction drawn between a decision that a party has lost the right to object and a decision that it has not done so. Now, in terms of the P&ID decision itself, if we go to paragraph 30, what made clear that the question of whether an appeal against the judge's decision on currency of the cost order falls within Section 68(4 is a matter of statutory interpretation. This requires the court to identify the meaning of the words used in Section 68(4 in context, having regard to the purpose and scheme of the Arbitration Act. And then the court found on this decision, at paragraph 31, applying that approach, there are a number of factors that point to a conclusion that the restriction in Section 68(4 is not meant to apply to the judge's decision to make the cost order in sterling. And at paragraph 32, it said that it wasn't inconsistent with the policy of limiting potential appeals for the purpose of avoiding delay and expense for a costs appeal to be allowed. It said at paragraph 38 that as a matter of normal meaning of words, the decision re the costs award was not under Section 38. At 41, which is particularly worthwhile looking at, it said in contrast to the situations in NIOC or diacumen, it is not easy to see how a decision on a final cost order following determination of a challenge under Section 68 could be regarded as being part of the process of reaching a decision on the Section 68 application, or as being within the compass of a challenge under Section 68. So you have those terms, part of the process or within the compass, being used as to where something would be under would be a decision under Section 68. And finally, at paragraph 45, the court observed that its decision that this didn't fall within Section 68(4) wasn't illogical. Now, the current case is very far removed from that. We say Mr. Andrew is attacking the decision made under Section 68, as his appeal is directed at the judgment on the Section 68 application, which forms part of the process or is within the compass by which the judge resolved the very Section 68 application, and he's seeking to set aside findings made in that context. And once you accept, as we say you should, that the findings against Mr. Andrew were within the four corners of the Section 68 application, then it follows that what he's effectively doing is seeking to set aside part of that decision-making process. Further, whilst it may be disavowed in this particular case by Mr. Andrew that the setting aside in this of those particular findings would lead to a change in the outcome, other cases might be very different. So if you imagine a situation in which rather than having a number of people acting on P&ID's behalf, you still had a company obtaining an arbitration award where it had only acted through one particular director, insofar as that director could then challenge the findings against him personally, well then that would take the entire basis away of the Section 68 decision, because the company can only act for individuals, self-evidently. So while here Mr. Andrew says, well, there were sufficient findings against other individuals that it won't affect the outcome, that applies here but may not apply in other decisions. So when you're construing the proper scope of the restriction under Section 68(4), the potential on another case for it to lead to a set-aside of the Section 68 outcome or lead to a remittal of that outcome does indicate that the power to allow an appeal in such circumstances is one that could lead to additional costs, could actually extend delay in relation to the arbitral process. So it's something where it's not simply costs after the event, it's actually something that could have an impact in terms of the parties.
The point about the previous appeal was that the currency of the cost point was completely collateral to the Section 68 decision. Now, whether that's right or wrong, that was essentially the reasoning. Whether it's right or wrong, I mean, I'm pretty certain the case is going to the Supreme Court with permission to appeal has been given, as I'm sure you're aware. Whether that's right or wrong, the issue here is, well, can it really be said that Mr. Andrews' attack on the findings that the judge made against him is somehow collateral to his Section 68 decision, and the short answer to that is it can't be, because it's part and process of the Section 68 decision.
Yes, and we say it represents a collateral attack on the 68 decision. And it's illogical, we say, for you to construe Section 68 as not preventing such collateral attack, in particular in circumstances where the actual parties can only appeal with leave of the judge.
Well, that's a sort of a point which wasn't lost on the court, actually, that if the parties can't appeal in relation, if the parties couldn't, if PNID itself couldn't appeal in relation to these findings against Mr. Andrew, which it couldn't because it didn't have permission from the judge and we wouldn't have jurisdiction. It's extremely difficult to see on what basis he can have a right of appeal unaffected by Section 68(4). And in respect to the same complaints, as it were.
Quite, my lord. And so we say even if Mr. Andrew had in principle standing to appeal as a non-party any aspect of the judgment under the approach in the Re-W case, nothing in that reasoning would entitle him to bypass the need for such permission to appeal to be sought and obtained from the High Court. So it doesn't say anything about what court you would have to go to, and you simply read them compatibly by saying, well, any such application for permission to appeal needs to be raised with and obtained from the first instance judge if there is to be any appeal to the Court of Appeal. So there's no inconsistency between the two areas. And we say there's nothing unfair to Mr. Andrew in this conclusion. He could have applied to the judge either by making a timely application for the consequentials hearing or by taking up the judge's invitation to issue an application with the judge reserving the ability to determine such application, and he chose not to. So unless I can assist the court any further, bang on 3, those are our submissions.
Well done, thank you very much.
There are a few points I'd like to make. Can I just start by returning to the question of whether the judge was functus? And it's the question of whether the judge was functus in relation to an application for permission to appeal. Nothing to do with whether it was functus as between the parties to the set-aside proceedings. Can I just take you back to the transcript of the court supplementary bundle at page 1 at 207. What the judge says, if you on page 9, says, thank you very much, Mr. Lee. I'm going to require a formal application supported.
Sorry,
So,
what page is this?
It's little internal page 9, starting at line 7.
Sorry, I'm in the wrong bundle.
It's 207 of the core supplementary bundle.
Page 207.
Yes.
Right.
You'll find there internal page 9. I was picking it up at line 7. Thank you very much, Mr. Lee. I'm going to require a formal application supported so far as appropriate by evidence as this is even to begin. This is a matter for you and your client as to how quickly that is done. If it's to be done, I'll reserve the matter to myself. The first thing I shall do if there's such an application is to give it consideration. There is a whole range of things I could do at that point. So the judge seems to have in mind that an application should be issued. It's very difficult to know what possible application one could issue. Permission to appeal is ordinarily sought.
Not for somebody who's not a party.
Well, he had.
What happened in Gray is Mr. Gray was joined as a party
Yes.
to the proceedings by an order that I made, I think. Pretty
Yes.
certain. And that may be what the judge had in mind. He may have had in mind that Mr. Gray would have to apply in the first instance to be joined as a party for the purposes of making an appeal.
But
an application to him, to the judge.
we make 2 points. First of all, we say that adjourning an application that has not been issued is not retaining jurisdiction over the issue. But more importantly, that's not the right question. The right question is whether he was adjourning the decision hearing by saying that. Have a look back, please, at the McDonald and Rose case in the authorities bundle 899.
Page?
899? 889.
Well, I'm really struggling to see what the real relevance of this is, though, because the fact is you didn't apply to the judge. And what we're addressing, this is relevant, isn't it, to the question of whether you should have an extension of time.
Exactly.
And you accept that you are out of time.
Absolutely.
So I'm not quite sure why the question of whether he was functus or not as between the 8th of
Well, in case the,
December and
in
when you
case,
applied.
in case this court was, I'm sorry, I didn't mean to cut across you, in case this court was concerned that it was a deliberate decision taken by Mr. Andrew for tactical decision.
Well, whether we can't say whether it was deliberate or not, and we've got your junior's email to the judge,
Yes.
in which he says you were functus, no disrespect. Well, that seems to have been what was thought on your side. If that's right, well, that's right, but it still doesn't address the delay that had already taken
No,
place before
it
the 8th
doesn't.
of
It's
December.
not a get me out of jail card. I agree.
And if you're wrong, then on Denton and White it may not help you anyway. Anyway, okay. So
I'm going to deal with it very shortly.
yeah,
I
sure.
agree. In the end,
889.
889, and it's McDonald Road, it's paragraph 3 on that page. If a party is not ready to make an application of the decision hearing, it's necessary to ask for the hearing to be formally adjourned in order to give them more time to do so. The judge, if he or she agrees to the adjournment, will no doubt set a timetable for written submissions, will normally decide the question on the papers without the need for a further hearing. As long as this decision hearing has been formally adjourned, any such application can be treated as being made at the decision hearing. And I've shown you the Lyle Mainwaring case where Sir David Eadie delivered his...
This is all absolutely basic stuff now,
Yes.
isn't it? Which is dealt with day in, day out in the handing down of judgments and
Yes.
adjourning for
Yeah,
consequential
we
matters.
quite nearly always hand down judgment in this court and then adjourn the consequentials.
Of course. But for this judge to have not been functus,
So in other
he would
words,
have to be...
if the judge has said, "I'll adjourn," I'll adjourn this hearing so you can make an application.
then he wouldn't be functus. Wouldn't be functus.
So
Then
the
we
fact
would...
that he didn't use the words, formal words, "I adjourn this application,"
No,
means he's functus.
it would need to be in his order.
Because it clearly contemplates what we debated with you yesterday.
Yeah.
The fact that he reserved it to himself it's necessarily implicit that he was saying, we're not going to deal with this now. It's going to have to be dealt with in the future. Therefore, so to the extent there are still outstanding matters, they're adjourned to be dealt with in the future.
But he can't give himself jurisdiction unless he formally adjourns for the second time the decision
And
hearing.
he can reserve jurisdiction to himself.
Well, it's not what
And if that's the same thing as adjourning, that's the argument.
But also, he hadn't given judgment at that point. He wasn't functus. He couldn't be.
But that's between the parties. It's a question of permission to appeal. If he doesn't formally adjourn the decision hearing so that an application can be made, he is functus. And in the Lyle Mainwaring case, which I took you to yesterday, Sir David Eadie delivered an oral judgment on Friday morning on the matter. He then got an application for permission to appeal later that day, and it was held. By that stage, he was functus.
Well, if you're right, the consequence is that on the 8th of December, you knew that the judge wasn't entertaining your application. You knew at that point that you were out of time.
Yes.
And so why did it then take you until
15
the
days.
21st of December to apply to this court?
It was a new team involved.
But you already had the grounds for appeal and the skeleton
Yeah,
argument. Rob.
Same team, you'd already served, you sent a letter to the judge on the night of the 6th, which I think was from you personally and your juniors, and you'd served grounds of appeal and a skeleton on the 6th. Why didn't you just serve an appellant's notice on this court on the 8th?
Well, that didn't happen.
No, it didn't, did it?
No.
No. So in a sense, the functus point is neither here nor there, because the real delay is the delay in applying to this court.
Well, I fully accept the functus point does not answer the question of relief from sanctions. And I haven't for a moment suggested that
No,
it
no,
does.
I'm nobody's suggesting you did.
No.
Mr. Walker.
Good. Can I just pick up the observation about, final observation about relief from sanctions? The final part of the Denton test is to evaluate the circumstances and deal with the matter justly and proportionately. And what I would submit is this: if your lordships were with me in thinking that there had been a finding which has seriously damaged Mr. Andrews' right to a private life and right to a fair trial, I know that's quite a big ask at this stage of the hearing, but if you were, I would suggest that it would surely be unjust for him not to be able to vindicate his rights in this court on the basis that, competently or otherwise, he misunderstood the rules and filed the application late. That's all I can say about Denton.
Yeah.
But that's where one brings back in the views of Lady Justice Gloucester, that the right place for your client to be vindicated is in the Solicitor's Disciplinary Tribunal.
Well, I'll come to that. I'm not surprised you find that attractive, but can I just revisit? I want to make a few observations about ground one, a few observations about ground two, a couple of comments on the articles, and one observation I think about 68.4. I'm not going to be very long.
Don't worry. I mean, the whole point is that as long as you don't repeat what you said to begin with, because
I'm trying not to.
I know you are.
I'm trying not to.
Yes.
So,
I always remember Mr. Justice Lloyd when I was being led by Mr. John Hobhouse, QC. Mr. Justice Lloyd saying to Mr. Hobhouse, the purposes of a reply is to reply, not to repeat.
yes. Well, I'm
Didn't
fully
stop
alive.
him.
I am fully alive to that. And apologies if I do slip into
No, don't
repeating.
worry. I'm only teasing a little bit.
I know.
Okay.
So, I think the other side accept that if paragraph 592 of the judgment is read as saying that Mr. Andrew has engaged in a scheme to bribe and corrupt Nigerian officials, then that would be a breach of his convention rights. That is because such a finding would be outside the four corners of the case and is not justified by any reasons. So the question on ground one boils down to this: what does 592 actually say? And as you know, our primary submission is that it does say that Mr. Andrew was party to P&ID's corrupt scheme. However, I also accept, as a result of discussions yesterday, there are two other possible interpretations. One is that the corruption just relates to his receipt and retention of the internal documents, and the other is that the reference to corruption doesn't implicate Mr. Andrew at all. Now, it was put to me yesterday that it didn't matter how the world interpreted 592. It was a matter for this court alone. We submit respectfully that cannot be right. If this paragraph is capable of at least three meanings, and one of which is that his reputation has been damaged in an unlawful way, it is no answer to say, well, the judge probably meant something else. The fact is that whatever his intended meaning, the judgment can be read as stating that Mr. Andrew was in fact party to a corrupt scheme. So
the point that we were making yesterday was simply the point that how the paragraph is to be interpreted. In other words, which of the three interpretations is the correct one is a matter for us. And what was said by the Daily Mail or whoever about it is neither here nor there. And
well, my response to that is this: we say you have to have regard to how 592 might be reasonably interpreted by a reasonable reader. And unless
forgive me, you can't appeal against an interpretation of a judgment which isn't the correct interpretation, but is one of a number of possible other meanings. You can only appeal against the correct interpretation, can't you?
Mm. Which is for us, not for the newspaper.
Yeah, I don't see that point. Ground two, as you know, that relates to paragraph 215 of the judgment. It contains two important findings. Mr. Andrew should have told Nigeria about the documents or immediately returned them because he was under a duty to do so. And secondly, that his decision to breach these duties was intentional. And we know this from the last sentence, which states in terms that he behaved in that way because of the money he hoped to make. Now, I submitted yesterday that was procedurally improper two ways. First, the judge didn't explain what duty he was under, and secondly, the judge doesn't explain what he knew or understood to be his professional duties, and thus could not have fairly concluded that he intentionally breached those duties to make money. As to the first, to make sure there's no misunderstanding, I accept that White and Withers and Immerman don't deal with privileged documents. I also accept that it's clear that if Mr. Andrew had realised that they'd been provided illicitly, he should have required his client to return them. And he effectively accepted as much in cross-examination as you've seen this morning. The judge made a positive finding that he should return the documents. The judge did not find that he should have stopped acting. But on the second question, you will have my submissions from yesterday that there was no analysis of whether he breached his duties deliberately. What we say is conspicuously absent from the finding is what he knew about his duties. In order to say that he purposely breached them, or breached an obligation to return the documents, one must ask what he understood those duties to be. There is no finding to that effect. What if, as he explained in cross-examination, he genuinely thought the right thing to do was to retain them because of the conflicting obligations to his client? The judge really needed to go through that exercise, and the judge really needed to follow his own guidance in the judgment at paragraph 24, which you find in the call bundle at 86.
Yeah.
In paragraph 24, judge says, I've approached dishonesty as guided by Lord Hughes in Ivy and Genting. When dishonesty is in question, the fact-finding tribunal must first ascertain the actual state of the individual's knowledge or belief as to the facts. The reasonableness or otherwise of his belief is a matter of evidence, going to whether he held the belief, but is not an additional requirement that his belief must be reasonable. The question is whether it's genuinely held. When once his actual state of mind as to knowledge or belief as to facts is established, the question whether his conduct was honest or dishonest is to be determined by the fact finder. And the judge just completely failed to go through that exercise. And Mr. Andrew is surely entitled, I would say rhetorically, and surely entitled to know why his explanation as to what his understanding was has been rejected by the judge and why he's effectively been held to be lying about it. There were no reasons given. So that's all I want to say about ground 2. Turning to Article 8, there are 3 points I want to make about Article 8. The first point is about the duty to give reasons. My learned friend says that Article 8 cannot possibly require a court to give detailed reasons when it makes findings about witnesses, but we've never submitted that the court, in this case, had a duty to give detailed reasons for all its findings. But the adequacy of a judge's reasons will depend on how serious the finding is, how much evidence to the contrary there is, and so on. So we accept, for instance, that the judge doesn't need to explain in detail why they formed a view that a witness was evasive. But if they form the view that a witness is deliberately misleading the court and lying on oath, that would attract a higher standard of explanation. And if, for instance, that witness has actually given copious amounts of evidence contradicting or contrary to the finding in question, the court must surely, at the very least, address that evidence, or say, yes, they can do it briefly, but it must be addressed. Now, as you'll see from grounds 1, 3, 4, and 5, the court just doesn't address any of Mr. Andrews' evidence as to why he behaved in the way he did. And he gave detailed evidence about the documents and his understanding. The second point about Article 8 and what it means for a finding to fall within the four come within the four corners of the case. And we suggest, I mean, the question is, as in Ray W., are the facts within the four corners of the case, and was it necessary for the judge to make the findings in order to fulfil his judicial task? And that's obviously closely related to the need to plead one's case, since that generally sets out the limits of the judge's task. And we say one should be very careful about simply saying the proceedings involved allegations of misconduct against Mr. Andrew. And when one asks the question, was it necessary to find that he was corrupt? The answer is no, because the matter was not pleaded and was not put to him. The third point about Article 8, it said that Mr. Andrew had adequate protection because he had advice from Mr. Treverton Jones and had a 7-day window beforehand down to make representations. Can I just remind you of what was said in Ray W. in paragraphs 95 and 96, which you've already looked at, so we don't need to turn it up again, but for your notice, page 1187, tab 46 of the authorities bundles. The court says, where in the course of a hearing it becomes clear to the parties and or the judge that adverse findings of significant outside the known parameters of the case may be made, consideration should be given to the following. And then there's then a list of procedural questions, and at 96 it said, once the judge came to form the view that significant adverse findings may well be made, he should have alerted the parties to the situation and canvassed submissions on the appropriate way to proceed. And we say there are two important points to extract from this. First of all, this should all be done before the judge delivers his draft judgment to the parties and makes his findings. And that's because the judge needs to ensure he has all relevant material before him before making his mind up. And the second point, as Ray W. makes clear, the onus is on the court to make sure that the affected person has, if need be, a right to make submissions.
So the difficulty with all of this, with respect, I mean, we haven't been shown the whole of Mr. Howard's closing submissions, but we've been shown enough from Mr. Howard's closing submissions to see that he made some very, very abrasive submissions about your client and his honesty in his submissions to the judge. Your client was sitting there, so we're told, throughout the trial, so he must have been there when Mr. Howard made those submissions. So your client, who's a professional lawyer, knew that there was always going to be a serious risk that the judge would accept those findings, or at least accept some of them, and make serious findings against him. So he had every opportunity after Mr. Howard had made those submissions to, at some stage, to say to the judge, especially since the judge took, I think, 10 months to produce the judgment. I'd like to make submissions to you, Judge, about why the things that Mr. Howard said about me is just simply not correct.
He wasn't aware that Mr. Howard, in his closing submissions, was making an allegation of corruption against him.
Well, never mind that point, but
Well,
so far as the
that's-
other points are concerned, going back to what we discussed yesterday,
No.
so far as all the other points are concerned, the findings the judge did make,
Well,
which
I
were
can't
based on-
possibly argue that Mr. Andrew wasn't aware that he was being heavily criticised for the internal documents. I can't possibly say that. Well, that's why I answered the...
the corruption point, if you're right as to what we make of 592, I see the point, but
Right.
if you're wrong, then it all falls into the same category, doesn't it?
Well,
He could have made, just as he could have, whether it was a result of Mr. Treverton Jones's advice or whatever, could have invited the judge to reconsider between the draft and the hand down.
he could have done.
He could have invited the judge to hear submissions from him about why what was being said about him wasn't true.
He could have done.
Yeah.
I'm
And if
not...
we're looking at it in Article 8 terms, that has to be part of our thinking, doesn't it?
Well, it's clearly relevant.
Yeah.
I'm not-
Yes.
The
Can't say it's not.
third paragraph of the closing argument said, in the third line, I think, they were offered life-changing sums of money contingent upon the success in the claim, which induced them to look past evidence of blatant corruption.
Yes, but
most obviously in the form of the FRN
Yes.
privileged document.
but that's not what the judge found against Mr. Andrew.
Well, it explains 592, doesn't it?
No, because it'd be very odd if 592 was using corruption in two different ways. If 592 was going back to the irregularities found against P&ID, which weren't irregularities.
Mr. Howard's paragraph 3
I agree.
was not dealing with the bribes to Mrs. Tager. It was using corruption in a much broader sense of dishonesty and fraud.
Yes.
Clearly.
Yes.
Because he couldn't have been saying looked past corruption because they looked past Mrs. Tager being bribed, because it wasn't the part of their pleading case that your client knew that she was being bribed.
Well, the only
So
point
it
I
has to
make,
be referring to something else, doesn't it?
yes.
I mean, as we discussed yesterday, if the judge had said, had used the word dishonesty in paragraph 592 rather than corruption, then we wouldn't be having this debate.
No, I must accept that.
No. Okay.
So anyway, all I was going to say is that, of course, the judge doesn't have to lay out the red carpet for Mr. Andrew, but if he had in mind to make a finding of corruption, as we've interpreted 592, he should have given Mr. Andrew fair warning. That's as high as I can put it. I get the point. I get the point about Mr. Treverton Jones, but I can't get into Mr. Treverton Jones's head, and I don't know what advice was given.
No.
So,
No.
can I just check this? I think, I'm told that the actual paragraph 3 of the closing submissions is all about the case involving Mr. Chassori's corruption. I'll just check that if I may.
Where is it again?
I think I've got a copy of 241 of the closing bundle.
Four supplementary bundles?
Yeah, tab
Uh,
15.
can't see why that's got to do with Chassori.
Starts, the second part of the story is P&ID's own lawyers.
Exactly. So I've been
Look past evidence of blatant corruption,
I
most
was
obviously in the form of the FRN
I've fed a
privilege.
point and I'm not convinced it's right. Will you bear with me for a second? I'm sorry.
No, absolutely. Just look at what's said at page 242.
Oh, I see. Well, the blatant corruption in that paragraph is referring to the case, the principal case that they were running, which was that Mr. Chassori had been corrupted, and it was Mr. Chassori.
Well, you say that, that's not how I read it.
I'm sorry?
That's not how I read it, or I think how my lord reads it.
It remained their primary case right to the bitter end that the lawyers had been corrupted.
But this is now talking about, this is making the assertion that they looked past blatant corruption, most obviously in the form of the privileged document.
Yes. I can't take that point any further. Can I move on to Article 6? My learned friend says that Article 6 doesn't apply to Mr. Andrew because there was no contestation or dispute of his right to reputation. Well, strictly speaking, such a dispute or contestation could only arise in a libel trial or a defamation trial. The logic of what he's saying is that Article 6 only applies if your civil rights are under the judicial microscope, and that what you're entitled to is a fair process in the determination of those rights. But we say that can't be right, and we seek to illustrate it by reference to Ray W. and the local authority was found able to assert Article 6 rights. That's at paragraph 103, tab 46, page 1189, 103, under the heading Local Authority Breach of Fair Trial Rights, have thus far concentrated upon the case of SW and PA with respect to fairness in the context of Article 8 and the common law. The local authority is unable to engage with the rights established by Article 8, but is entitled to the benefit of the right to a fair trial established by Article 6 of the European Convention, and to similar rights under the common law for which see above. During the hearing of this appeal, no issue was taken to the effect that there was a distinction to be drawn on the facts of this case between the fair trial rights of the individuals on the one hand and the local authority on the other. Now, presumably my learned friend would argue that Article 6 applied to the local authority because its civil rights and obligations were being determined. These were care proceedings, so the obligation that was being determined was the extent of the local authority's duties to the children. But here's the thing, the process of doing that was completely fair. There was no suggestion that the trial judge presided over an unfair trial of the local authority's care obligations. Rather, the local authority's complaint was that the judge went outside the scope of what he was being asked to determine. What was unfair about the judge's process wasn't that he decided the issues before him unfairly, it was that he decided to choose issues that weren't before him and did so in a procedurally unfair manner. So whilst this isn't considered in any real detail in Ray W, the local authority can't have been invoking Article 6 on the basis that its civil obligation with respect to the children was being determined, because there was nothing unfair about that process. It could only have been on the basis that its right to reputation was being damaged and tarnished by extraneous findings. And the same applies to Mr. Andrew in relation to the finding of corruption. Can I quickly address the court on the Governors of X school case, which was handed up last night? The short answer is it's not relevant to the present facts. As you know, that case involved a disciplinary committee which made findings of misconduct against a teaching assistant. The matter was then referred to the Secretary of State for Children, School and Families, who had the power to give a direction prohibiting the teaching assistant from ever working with children again. The teaching assistant argued that the committee breaches Article 6 rights. The civil right which the teaching assistant alleged was being determined was his right to work as a teaching assistant. Crucially, he admitted that only the Secretary of State's decision was truly determinative of this civil right. His submission was that disciplinary committee proceedings, whilst not being directly dispositive, were hugely influential of the Secretary's decision and was in that indirect sense dispositive. Now, that might be relevant if we were saying that Mr. Andrews' civil right to be a solicitor was affected by the judgment, because on the basis that the judgment would have significant influence in any SDT proceedings. But Mr. Andrews is relying on a civil right to reputation, and that has been determined. And whilst the Supreme Court emphasises that the jurisprudence on what amounts to a determination is to be approached on a pragmatic, context-sensitive basis, see paragraph 67 on page 1. Sorry, I'm rephrasing. What the court emphasises is that the question of determination has to be approached on a pragmatic, context-sensitive basis. See paragraph 67 on page 193. And what I say is that in this context, what matters is that Mr. Andrews' right to a reputation has been effectively tarnished, and badly so, without a fair process. My learned friends relying on Boré say that the granting of relief would interfere with Nigeria's Article 6 rights. We disagree. The starting point is the concession that my learned friend rightly made. Treating the adverse findings as not having been made would not affect the order. It would not even affect the integrity of the findings of serious irregularity, because that rests on P&ID's corruption, not any dishonesty or breach of duty on Mr. Andrews' part. Instead, he rests his submission on the risk that if we pull on this string, we don't know what might unravel. He says there's a risk that P&ID might jump on any judgment on this court to try and upset the judgment. But my learned friend is unable to point to any lawful or proper basis for P&ID to do so. That's because it doesn't exist. And we say that on their own case, allowing this appeal would not enable P&ID to challenge the order and the judgment, and it creates no additional danger or risk posed to the finality. I've got one final point to make on section 68.4. You already got my submissions on that. But I have one additional submission, which is this. Parties' right to appeal in the High Court, of course, derives from section 16 of the Senior Courts Act. And it is this right, we say, that section 68.4 was designed to limit. We know, however, that Mr. Andrews' right to appeal against mere findings doesn't come from section 16. It comes, as I have explained, and the Court of Appeal explained in Ray W, from section 7 and 9 of the Human Rights Act, which provides that a party may rely on his convention rights in respect of a judicial act by exercising a right of appeal. So section 68.4 can't have been drafted with this route in mind. This is not least because the Act preceded the Human Rights Act. But also, the reason that sections 7 and 9 of the Human Rights Act exist is to give effect to the principle that persons must have a right to an effective remedy for breaches of their convention rights. The effect of construing section 68.4 here, in accordance with Nigeria's submissions, would be that a person's right to assert his convention rights could be stopped short by the very person he says has breached those rights. As I submitted yesterday, the courts can and should read down section 68.4 in order to create the effective remedy which the convention requires.
That reasoning would also apply to a party, wouldn't it?
Yes,
Must do. So in other words, P&ID could come to this court and say, well, never mind that section 68.4 applied so that we couldn't come to your court because the judge had refused us permission to appeal. The fact is the judge made findings which have affected our human rights under Articles 6 and 8 in the same way as they affected Mr. Andrews' human rights, and that's by that route we're entitled to bypass section 68.4 and all the finality which that entails.
but Mr. Andrews is in a very different position, isn't he? He was a mere witness. He wasn't
He's
a
a bit
party.
more than a mere witness.
Well,
He's the owner of the company.
Yes, he was, okay.
I was asking myself in commercial terms, could P&ID pop up later and try and as it were, reappeal, given that Mr. Andrew is actually somebody who owns the company, or has I can't remember, he's 100% owner or substantial owner. That rather increases the risk which you were telling us a moment ago doesn't exist.
Well, we would say that 68.4 properly understood, if the judge first instance says no right of appeal, that's the end of it for the parties. We say that a witness who has not been party to the original arbitration, is not party to the set-aside proceedings, is in a different position.
That can't be right.
That can't be right.
If your argument is right, then a party can also avoid 68.4 if they have human rights arguments, because the same argument would apply. Why should the judge who breached those rights be the sole arbiter of whether there's a right to appeal?
Yeah,
And that would drive a coach and horses through section 68.4, because in any case where a party can frame their appeal on the basis that their rights have been infringed, including possibly their rights to property, they would be able to come to this court notwithstanding 68.4.
And a large number of section 68 applications which are heard in the commercial court are ones which involve, because it has to involve serious irregularity, certainly in my experience, it quite often involves allegations about the way in which the arbitrators have handled the evidence of the witnesses at the hearing, or that they haven't afforded people, the right to be heard in the way in which they should have done. So that it, as my lord says, it would drive a coach and horses through the finality that's intended by section 68.4. Anyway, we've got your submission.
You've got my submissions. I don't think I can add to them. Thank you very much.
Is there anything else?
No, thank you.
Very much, Mr. Hall. Thank you. Thank you. Right. Well, thank you. Thank you all very much indeed for your interesting and helpful arguments. We'll obviously reserve our judgment, make no promises as to when you'll get a draft, but when you do get a draft judgment, please pay attention to the terms of the embargo at the top, and provide the court with any typographical and similar corrections. It's not intended to be an opportunity for the parties to re-argue the substance of the decision of the court. And if when the time comes you could possibly agree a draft order, then do so. If you can't agree a draft order, either provide us with written submissions as to why you can't agree it, or with a timetable as to when you're going to deal with the written submissions as to why you can't deal with it. Okay? Is there anything else? I think not. Thank you very much.
Cool, guys.
Enjoy the bank holiday sunshine.